Good afternoon, everyone, and thank you so much for joining our webinar Benefits Strength Test, Flexing the FSA. My name is Amanda, and I'll be your moderator today. ERISA attorney Larry Grudzien is our presenter. We're seeing a lot of possible changes coming for FSA administration as recently as last night. So if you miss anything, don't worry. We'll be emailing you a recording and the slides after the webinar concludes. I'll be keeping the webinar muted to avoid any background noise. Larry will pause periodically for questions. Just type your question in the box below, and I'll read it aloud for you. Our next webinar will be on March 21st at 1 p.m. Central Standard Time. Keep an eye on your inboxes for your invitation. Without further ado, I'm going to turn the presentation over to Larry.
Thank you very much. What I'm going to try to do today is talk about the issues that employers are facing when they sponsor a FSA, and this is health flexible spending accounts. What are some of the trials and tribulations, what are some of the special rules? And it baffles many employers because it can get complicated. And what even complicates it even more is that with the new healthcare reform rules coming in, probably over the next 6 to 8 months, all the proposals are going to be affecting FSAs. So FSAs will not be going away. I think many of the rules that were in place before healthcare reform are going to come roaring back. And the issue I want to really kind of let you know is it's going to be up in the air, especially when healthcare reform is repealed, whether carryovers will stay. We don't know at this point. So I'm going to raise a lot of questions. I'm going to discuss a lot of issues. And as Amanda indicated, I'll be stopping for questions. And again, a way that you can ask questions, there's a questions tab on the dashboard that you can type in your questions, and we'll address any questions that you have. So what are we going to be talking about today? Well, we're going to talk about allowable election changes. And that's always baffling to employers because they really don't understand under what situations an individual can change their election under a health FSA, because very limited situations do apply to FSAs. And generally, as a good rule of thumb, is that anything dealing with a change in cost and coverage does not apply to FSAs. And I'll give you a fine example of how that happens. Many times the medical plan has a different plan year than the health FSA. Many times employers do health FSAs on a calendar year, and they have their medical plan at a different time during the year. And in the middle of the FSA plan year, the employer switches to a high deductible plan and they add an HSA. Well, the problem is going to be you can't give an employee under an FSA an election to change their election because a change in coverage is not an event, as you're going to see in a few minutes, under FSAs. So the only way, if somebody is participating in a health FSA and they want to participate in an HSA, they can't rescind their election. The only way they could is if the employer, for example, amended the FSA to be a limited purpose FSA, all right, but you can't give the employees an election. So that's what many employers are facing, especially if they want to offer HSAs. And I'll be talking about the interface between the two in the next few minutes, but that's something to really understand. So very limited situations can you change your election. Another thing I'll be talking about is carryovers. And again, the IRS put it in 2013. It has some advantages, but also has some special rules, which I'll be covering in a few minutes. I get questions about this all the time. Also, there's some special rules that apply to FSAs and COBRA only if the FSA is considered to be an accepted benefit. And I'll be discussing what that is. So you have to understand that, yes, COBRA does apply, but it's a different type of COBRA. And you should be made aware of that because I run into situations that employers don't understand when you have to offer COBRA in an FSA situation. Next, I'll be talking about HRAs and FSAs, how they interface with each other, and some special rules you have to be very cognizant of, because many times employers, as they amend their health plans to be high deductibles, what they may do is add an HRA in there, and you have to be very careful how that works with FSAs. Next, I'll be talking about HSAs and FSAs. You've got to be real careful between the two and when they interface and in what situations, because carryovers can affect it. Also, if you want to institute a high deductible plan, as I indicated before, in the middle of the year, that can affect it. So there's all kinds of issues and problems if you have an FSA and you want to add an HSA. Next, I'll be talking about health reform changes. What happens, what goes away if it's repealed? And as Amanda indicated, last night the House Republicans did their health reform changes, and there's tons of things in there that affect FSAs. And the first thing I noticed that all the rules that were part of healthcare reform, the $2,500 limit, for example, the over-the-counter drugs, all those rules go away. So all of a sudden we're back to 2009, which I'll be discussing. So I'll be talking about what happens if there's a repeal. And lastly, this is an uncharted territory, is what happens if there's a mistake. What can you do? And this is a very common situation where somebody comes to you and said, I signed up for an FSA and I didn't understand it, and I want to take it back. Under what situations can you take it back? And when should you take it back? So I'll be talking about that. So let's get started on this. So let's look at the allowable election changes for FSAs. Generally, as an employer, if somebody, and you have to make this very clear to your employees, if they sign up for an FSA, only under certain circumstances, and there's qualifying events that the law does allow an employee to change their election. And some situations are employees come to you 2 or 3 weeks after the year started and they say, wait a minute, I really can't afford this, I want to drop it. And basically you have to tell them that, I'm sorry, but you made a commitment for the year, and only under these particular situations, and there's 5 events that you can change your election mid-year under an FSA. So again, every year an employee makes a different election. Now there's other events I'll be discussing that you could change a person's elections. I'll be talking about that. And there's certain administrative requirements that must be met for implement a mid-year election change. When is it effective? How does it affect any current claims? What are you going to allow if somebody wants to reduce their election? Under what circumstances? So I'll be talking about that, and all these factors are important. So these are the 5 different events that will allow an employee to change the election under a health FSA. Change in status, losing a job, gaining a job, getting married, having a child, moving to another area. If it affects eligibility for plans, could allow an individual to change their election under the health FSA. Also, COBRA qualifying event. Somebody goes on COBRA, they can change their election. They can decide not to elect. They can change their election. Judgments, decrees, and orders. If somebody has a medical child support order, all of a sudden they have to cover their child. Now, hey, I want to participate in the cafeteria plan. I want to put money aside so I can pay for some of the expenses. Next, entitlement to Medicare and Medicaid, that including losing Medicaid and Medicare. You can change your election, you can drop your plan. And then family and medical leave absence. In that situation, somebody could change their election, decide during the leave not to participate under the health FSA, and then afterwards decide to rejoin it after the leave is over. So these are now, as an employer, you can choose to add all 5 or some of the 5. It's up to you what you want to do. But remember, for all the other plans, premium only, for example, there are a number of different elections, and one is that's absent from here is special enrollments. Now, the change in status is kind of close, but again, what isn't included in that is loss of coverage. So any change in coverage, change in cost, that will now allow you to change your health FSA election. So what are the change in status events encompass? Includes change in employee's marital status, change in the number of dependents, change in employment status, dependent satisfying or ceasing to satisfy dependent eligibility rules. And that many times happens when somebody comes from overseas. Now all of a sudden they can be covered, or because of adoption, that type of thing. It could be birth. Also, there's change in residence. All of a sudden you move to an area that doesn't have coverage, so you want to change your health FSA election because now you have a different plan, and because of that, the change in residence, you have whole different coverage. Now, it's not the change in coverage, it's the change in residence that allows you to change your election under the health FSA. Also, commencement or termination of adoption proceedings also gets considered a change in status. Change in marital status includes marriage, divorce, death of a spouse, legal separation, or annulment. Now, remember in this situation, it's not the filing of the divorce, it's not the filing of the legal separation, it's the court determination. So in that situation, you have to have evidence of the divorce or the legal separation or the annulment. Just filing it is not enough, so please understand that. Change in number of dependents. It could be a birth, adoption, placement for adoption, or death. All can allow an individual to change their election. So here it includes children or any dependent that's under the code section 105H. So it could be other relatives that would qualify as a dependent under your plan. Change in employment status. It includes termination or commencement of employment, strike or lockout, commencement and return from unpaid leave, change in work site, change and any change in employment status, and this is important, that causes the change in eligibility. So if somebody goes from full-time to part-time and all of a sudden they lose their eligibility for the medical plan, that could affect the ability of an individual to participate under the health FSA. And the only way in some situations you can either continue coverage or continue your participation under the health FSA is under COBRA. So again, that's a situation you have to look into. So dependent satisfying or ceasing to satisfy dependent eligibility. It could be attainment of a certain age 26 for children, marriage or other similar situations. That you had stepchildren, you divorced the mother, now there's no relationship between you and those children anymore. They're not your children anymore. So that could affect your ability to change your election under the health FSA. Change in residence. Now, what's important here, it has to be a change in, it's this change in residence of the employee, spouse, or dependent. And what's important here is this slide indicates the change in residence has to change the eligibility for health coverage. So coverage may be dropped where the coverage affects the ability for the managed care option. And again, a change in residence could allow you to up your election under the health FSA because you had to change your, as I indicated before, you had to change your coverage. Now, there's a number of different rules, and I'm not going to go through them in detail, but just understand there's a consistency requirement, which means that the event, the change you make has to be consistent with the event. So if you lose coverage, or you have, for example, lesser coverage, it may affect the ability to increase or decrease your health FSA election. So if, for example, if somebody loses as a dependent, in that situation, you may want to decrease your election of the health FSA as opposed to increase it. In other words, your expenses are going to go down. So this consistency requirement is extremely important. So if a change in status occurs, a plan can only permit employees to make elections that are consistent with the event, and there's 4 general consistency rules, 4 special rules. There's a special rule for group term, life, disability, any change you can do. Special rule for dependent care and adoption expenses. I'm not going to cover that, just know it's there. Special rule for loss of spouses or dependents eligibility. In that situation, an employee can cancel accident and health coverage, and election to cancel coverage for anyone else fails to correspond. Special consistent rule for gain of eligibility under another employer's plan. It could affect your ability to make an election. General consistency rules. Under this rule, an election change satisfies the consistent rule if the election change is an account of or corresponds with a change in status that affects eligibility of coverage under the employer's plan. So again, the event has to affect the eligibility of coverage. And again, if somebody loses the ability to be dependent, then basically you can make the change, and the change is decrease in your FSA election. So again, change in status must affect the eligibility for coverage. Gain or loss of coverage eligibility in the component plan or cafeteria plan which satisfy the consistency requirement, and a change in status that affects eligibility includes an increase or decrease of the number of employees, family members, and dependents. And the election change must be an account of and correspond to the event. So again, this is extremely important. You have to be very careful, and there's a lot of gray lines here. The second event is COBRA qualifying event. A cafeteria plan may permit an employee to make a mid-year election change if the COBRA qualifying affects the employee, spouse, or a dependent, and in that situation, the employee may increase pre-tax salary reductions to cover the COBRA premiums. If they have the, for example, that could be the case if somebody has a reduction of hours, they're still working. But again, you could change your FSA election because the fact now you could terminate your FSA election under a COBRA qualifying event. Judgments, decrees, and orders. In this situation, a cafeteria plan may allow mid-year changes on account of judgment decrees or orders. This is in dealing with qualified child support orders. In that situation, you are participating in a plan. Now the court is forcing you to cover your child. Now you can start participating under the health FSA and cover those expenses not covered by your plan. So it allows you in that situation to either participate under the health FSA or increase your election. Entitlement to Medicare or Medicaid. In that situation, again, once you become eligible for Medicaid, what you can do is you can terminate your or reduce your FSA amount. Now, the other flip side of this, if you lose eligibility for Medicare and Medicaid, you can increase, and that's the consistently rule again, you can increase your election under the FSA. So the losing of Medicare and Medicaid allows an employee to elect or increase the FSA amount. And again, that's the consistency rule. And lastly, in regard to family and medical leave absence, in that situation, if somebody goes on family and medical leave, then they have the ability to change their election under the health FSA. So a cafeteria plan may allow a mid-year change on account of a leave of absence under family medical leave. An employer must allow all election changes available to employees on a non-family medical leave. A plan must allow employees to revoke health care coverage. an employee can reinstate coverage upon return. So you can continue your participation under the FSA or you can cancel it. So again, it's up to the employer what they want to do in this situation. Other events that may permit mid-year changes, military leave under USERRA. In that situation, somebody can change their election under the FSA. Mistakes made by the employer or the employer. The most common mistake individuals make is, and this I've seen time and time again, where somebody decides they're going to participate under the dependent care program, not understanding that the dependent care program is for the custodial care of their child, not providing reimbursement for medical care. And all of a sudden, after they realized 3-4 weeks afterwards that they made the mistake, come back to and said, I'm sorry, I misread the SPD, I didn't understand it, could I change my election? And I always tell people in that situation that it depends when that employee comes in. If that person comes in a few months after making the election, I would think it's probably a gentleman's excuse. They didn't understand. But if they wait 6, 8, 10 months and come back, I would question their sincerity of whether they really did that for that reason. And as an employer, you can draw a line at various places. Now again, this doesn't happen too often. A participant fails medical underwriting, they can't participate. Mid-year election changes may be required to pass non-discrimination testing, especially when you're dealing with a highly compensated individual. Those changes are going to be automatic. Once you do the non-discrimination test and you realize that person cannot put as much as they thought they would have been. And then in situations like fraud where there's automatic loss of coverage, in that situation, you can allow changes for that. So again, when you're administering these mid-year changes, you basically have to obtain substantiation for the reason for the change. You should have a form that the employee makes you aware of exactly what it is. And again, if it's an event, for example, where someone is getting a divorce, you need to get those divorce papers. And then you'd have to decide when the election change is effective. Is it the next pay period, beginning next month? And again, those rules should be in your SPD, indicating to the employee when the election changes. And what you can do, you can limit in your SPD how many times a year somebody can make election changes. Some say once, twice, once a month. It doesn't happen too often, but it could. And again, confirm that the cafeteria plan regulations allow such change. Sometimes it's cloudy. And this is something that's very interesting, is that you have to look at your cafeteria plan document to see if all the events I've just stated in the previous slides are indicated in your plan document. Many times, if you buy a cafeteria plan from a vendor, it may not have all the events. And also what's interesting, and this is not so much the health FSA, but also other coverages. If the cafeteria plan contradicts the insurance policies in regard to other coverages, the insurance policies win. They don't have to allow a change, a revocation. So that's more affecting other coverages, not the health FSA. Amanda, are there any changes or any questions? I'm sorry. I got changes in my mind.
Yes. Would a child turning 26 and aging out of the plan count as
Yes.
an opening? Yes?
Yes.
Okay. And that's all
That's the best example of losing a dependent, because in that situation that person loses coverage under the group health plan. Mm-hmm. And because of that, then you can drop them from the health FSA.
Gotcha. All right. That's all we have for right now.
Okay. The next area I want to cover, because it gets somewhat complicated, is the whole carryover rules. This was first allowed in 2013. Under these rules, FSAs, and again, this is not something you're required to do. You can offer a carryover of unused balances up to $500 remaining at the end of the plan year to be used for qualified medical expenses incurred in subsequent years. And the offering of health FSAs is optional, as I said before, as an alternative to offering health FSA grace period. You can offer one or the other. Now, as a side note, remember in the past, this was I think 2006, the IRS allowed individuals to carry over unused amounts for 2.5 months. And it was unlimited. Now here they've offered another option, but it's one or the other. You can have both. And the advantage of the carryover is the fact it can be, if you want to, the carryover can be unlimited as long as that person remains a participant, but it's limited to up to $500. So it's up to you which one you want to pick. And the reason why these are important, because one of the biggest stumbling blocks in employees participating in a health FSA is like buying a cell phone and the cell phone operator says, I have 6 plans. And what do you think, how much data you're going to use each month? Because each plan is different. And you say, I've never looked at my bill that much. I don't know. And the same thing is facing individuals that all of a sudden they have to fill out and say, God, what are my expenses going to be for the coming year? I have no idea. So you have to pick, you know, at what level, because if you underestimate, all of a sudden, you know, you lose out. But if you overestimate, and all of a sudden you put in $2,500, but you only have expenses for $1,000, oops, you can lose all that money. Now that $500 at least alleviates some fear and said, okay, you know, if I under or over guess by $500, big deal. At least I have additional time to spend the money. So it may encourage, a carryover may encourage more employees to participate because the fear of losing the money is less. So again, very important. So this is an exception to the use it or lose it rule, where it says if you don't use the money by the end of the year, I'm sorry, it's gone. So the grace period and the carryover is an exception to that. So amounts carried over are available to reimburse eligible medical expenses incurred in the subsequent plan year. Since offering health FSA care is optional, the plan wishing to all carryovers must specifically provide the carryover. So again, if you want to do it, you have to amend your plan documents by the end of the previous plan year. The carryovers, if they're offered, the same carryover rules must apply to everyone. The uniform coverage rule applies, so if somebody carries over $500, they can use it up relatively quickly in the next year. And the amount that the employee can carry over is based on the health FSA amount remaining from the plan year at the end of the run-up period. Now remember, and this is important, and this is a common question I get about carryovers. When can I start using the money as a participant? And I tell people technically it's not available until the end of the run-up period after the end of the plan year, because only then do we know how much is remaining to be carried over. So you can't start using that money 15 minutes after the subsequent plan year starts. We have to wait and say, you know, you can use your current plan money, but you can't use the carryover money until the run-up period ends, because we don't know how much expenses you have in the pipeline. And we have to wait and see. So if your run-up period is 90 days, 60 days, at the end of that run-up period, when the books for the plan year are closed, then we say, aha, all your expenses are in. Now you have $400. Go ahead and spend it. And 15 minutes after we make that determination, you submit a bill for $400, and that money is gone. Okay. So it's very important to explain that and make sure employees understand, because they could get very frustrated and say, hey, wait a minute, I thought you said I could use it. Yeah, but we need a period of time to determine how much will be carried over, which is extremely important. So again, after the runout period, any carryover exceeding $500, as this slide indicates, it will be lost, and then that individual will be allowed to carry over up to $500 for the next year. So again, during the runout period, any potential carryovers will be again used for the previous year, and only after the runout period can it be used for the current year. So during that period of time, plans may reimburse current year claims first from current year amount. So if somebody signed up the next year, we can use current year money and then wait to use the carryover money. So using current year contributions first leaves potential carryover amounts available to reimburse prior year expenses submitted during the runout period. Conversely, reimbursing current year expenses from potential carryover during the runout period will reduce the amount available to carryover. So you have to make sure that everybody understands that during that runout period, their first priority is to pay prior year claims. Then after that, we can use it for current years. Now remember, and this is something to really explain to employees, and this is a big one. If somebody has a carryover amount, that carryover amount basically ruins someone's ability to be in an HSA for the entire plan year. So if that person has $100 sitting in his FSA after the runout period, I'm sorry, but you're unable to participate under a HSA. It prevents you. So that's one of the advantages of the grace period. The grace period was only 2.5 months. Here, the troublesome part about the carryover, once that amount is carried over, you lose HSA eligibility for the entire year. And in some situations, what employers do, and you have the ability to do that, you can give the employees the ability to change the character of the FSA, and that election has to be put in by the end of the previous year. So you can say any amounts carried over, because I want to participate under under a HSA. What I'm going to be doing is I'm going to be changing. So you can either give the employees the ability to change the character, or you can change the character. You as an employer can do that. So again, or in some situations, what the employer does is give the employees the ability to decline the carryover. Say, I'm going to participate under a HSA, and if I have any carryover, sometimes it could be a few dollars, $50, $100. Sorry, but I'll lose it because I want to participate under an HSA. So this is extremely important to explain to employees the effect our carryovers have under HSAs. Will carryover affect the health FSA's status of an accepted benefit? Remember, that's an important determination, because and I'll be discussing that in the next few minutes what that is, but if a health FSA is an accepted benefit, then it's not subject to many rules. There's special rules involved, and what the IRS said, it does not. What COBRA issues are presented by a carryover, as this slide indicates. Health FSA carryovers are included when determining the benefit that the qualified beneficiary is entitled to during the remainder of the planned year. So it increases the amount that's available. There's no COBRA premium for the carryover, and carryovers are not counted for purposes of determining the COBRA premium, as I said before. But again, the carryovers must be counted in determining whether the account is overspent or underspent. So it's used for certain purposes and not for other purposes. Can employers limit the carryovers to employees who elect salary reduction? Yes. So there's 2015 guidance that indicated you as an employer can decide who's eligible, and you can make one of your conditions. Okay, if you're going to participate and allow a carryover, you have to elect some money currently under the health FSA, so you can do that. Can the employers limit the carryover period? Yes. Even though the statute indicates that it's unlimited, you can say 1 or 2 or 3 years. That's the limit. We're not going to account for that money because additional cost of administering the health FSA to count all this money that you have. So therefore, in that situation, we're going to limit it to 2 years. So again, that additional administration could add up and could add to the cost of administration. So employers have that ability to limit the number of years that carryover is done. Can employers establish a minimum carryover amount? And as an employer, you can say, if it's less than $50 or $25, I'm sorry, you lose it. It's going to be more than a certain amount. So again, it's up to you to determine in your SPD and in your plan documents what the character and what the administration of the carryovers are, and you have to communicate that to your employees. Are carryovers factored in non-discrimination testing? The carryover guidance does not address whether carryover amounts must be factored into non-discrimination. An IRS official has informally commented that carryover amounts will not be taken into account in non-discrimination testing for subsequent year. So, for example, if all the highly compensated carried over amounts, it's not considered in your non-discrimination testing. Extremely important to understand that. So, Amanda, any carryover?
Yes, we do have some questions. First, can an employee elect an FSA if they do not have the employer's medical plan?
It's up to the employer to make that determination, because you'll see this in the next few minutes in the COBRA rules. In order for an FSA to be considered to be an accepted benefit, you have to at least offer the health plan to the employee, and the employee then has a choice of whether to participate or not. But no, the employer doesn't have to, but they must be offered the health plan. Most employers, though, make that a condition of participating under the health FSA.
Okay.
You can do that.
If an employee has a legitimate change and elects more with only 2 months left in a plan, how does the employer attain that additional money?
Well, in that situation, you can limit the amount of the change. So if you can't get it out in COBRA premiums, you can say, I'm sorry, you're limited to what you can change it to. So the employer has that right.
Okay. If a spouse of a person works in a temporary position and that position becomes permanent, can they join the FSA if they are allowed to join the medical coverage of the spouse?
If it changes the eligibility, yes. If that's a change in status, and that person all of a sudden becomes eligible for the medical plan, yes.
Okay.
That will affect your FSA eligibility, because you may want to decrease it.
Yeah. If the employer chooses carryover, can employees still submit prior year reimbursements through March 31st?
Yeah, the runout period still is in place, and that's an important fact, because the fact that will determine the amount of the carryover. So that runout period is extremely important. Now remember, and this is and this is one factor that employees don't understand, and former employees don't understand. You can have two different run-out periods. One for active employees after the end of the year, and a run-out period, another run-out period for those who terminate. Most employers limit the run-out period to 60 or 90 days after the date of termination. That's got to be clearly indicated in your plan document and your SPDs. I don't know how many times employers come to me and former employees are very upset because they submitted a bill and the employer won't pay it because it's after that 60 or 90-day period. And you have to put it in underline and wrap it in a bow so former employees understand they have a limited period of time to submit any claims.
Mm-hmm. Just a clarifying question. If you choose grace period, does that mean that you aren't limited to the $500 carryover, but you only have 2.5 months to use it?
Correct. You are correct.
Okay.
That's it. That's the advantage. That's the advantage of having a grace period. So there's advantages and disadvantages of each.
So if you have a lot left over, but you're having major surgery in January, you'd choose
right.
Grace
but I mean,
period.
the employer has to pick one or the other. I mean, that's the problem. You can't have both.
Yeah, I understand. Can HSA start in the middle of a year bypassing the carryover time period under the FSA?
Well, the problem in that situation, the carryover makes you ineligible for the entire year because you're deemed to be having to use it for the entire year. So even if you use the money up in the middle of the year, it still prevents you from participating under a HSA. That's the problem.
Gotcha.
The carryover is different because it's a limited period. It's only 2.5 months, while the carryover is for the entire next year.
Sort of a follow-up, at what points in the year can an employee decline the carryover into the coming year if they should want to be eligible for an HSA?
Prior to the beginning of the year.
Okay.
So during your open enrollment, your employer can give you a choice to decline it. And depending on what your employer does, some don't. They say it's automatic. I'm sorry, if you have money left over, it automatically rolls over. So you have to look at your plan documents, see how much flexibility your employer has. Gotcha.
All right, well, that's all for right now.
All right, let's look at the COBRA issues. Here, health FSAs or group health plans are subject to COBRA. Health FSAs that are subject to COBRA must offer COBRA coverage to qualified beneficiaries who lose coverage as a result of a qualifying event unless the special limited COBRA obligation must provide all COBRA notices, including initial notices and election notices. And remember, in your material, you have to include health FSAs in the explanation on when COBRA applies. IRS representatives have been formally indicated that IRS will view the family members other than the covered employee are entitled to elect COBRA under a health FSA. So most employers don't do it. The law says otherwise. So if a health FSA meets certain conditions, then there's a limited COBRA obligation. All right. COBRA coverage need not to be offered to qualified beneficiaries who have overspent their accounts as of the date of the qualifying event. What does overspent mean? It means that you look at the date of termination of coverage, and if the amount remaining is less than the COBRA premium for the remaining period, that means that you've overspent your health FSA. So let's say you have 6 months remaining, and let's make it easy. And let's say that person was putting in $100 a month, $1,200 a year. He quits in July. He spent $1,000 already. He only has $200 left. In that situation, for those 6 months, the COBRA premium would be $600. He has $200 remaining. I'm sorry, we don't have to offer COBRA to you because you've overspent your amount. But let's say on July, that person's only spent $200. There's 6 months left. That person is underspent their account, so therefore the employer has to offer them COBRA. And remember, in this situation, as soon as that person spends their money, they don't have to spend another dime on COBRA premiums for the health FSA. So to qualify, and again, there's a limited COBRA period under what we call accepted benefits. To qualify, health FSA must provide accepted benefits, and the COBRA premium under this must meet certain requirements. Benefits provided under health FSAs are accepted for a class of, if the health FSA is an FSA, which it is, and one, the maximum benefit, the employer contributions does not exceed $500, and two, the employee was offered group health coverage. They don't have to be covered, but they have to be offered to it. If that's the case, if you meet both requirements, then in that situation, then the health FSA is an accepted benefit, and the COBRA period is not 18 or 36 months, but it's until the end of the plan year. Now, in this situation, most health FSAs don't have employer contributions. If that's the case, or the employer contribution is limited to $500, and the group health plan is offered to everyone, then this limited COBRA obligation applies. So here, you're only required to offer coverage until the end of the plan year in question. So again, this slide explains exactly how to determine whether the account is overspent. And again, at the time of the qualifying event, you look at what the remaining period would be. In my example, let's say it's $100 a month again. At a time of qualifying event, what is remaining in the account, and you compare it to what the remaining COBRA premiums would be. And in my situation, the COBRA premium, the employee had picked $100 a month. So if there's more in the account than the COBRA premium, the account is underspent, as this slide indicates, and therefore we have to offer the employee COBRA. Amanda, are there any questions about COBRA?
Yes, hold on one second. If an employee used all of their FSA by March and leave in April, do they have to pay the employer the remaining deductions that were divided by 24 pay periods?
No. No. You could never ask for money back from the employee, even if they beg you to give it back. No, it basically, a health FSA is like insurance. And let's say in January, somebody, the previous year, somebody has elected the full $2,600 limit. In January, they have surgery and they spent the whole $2,600. And then 2 weeks later, they give their notice and leave. The employer's on the hook for the entire $2,600. That's called the uniform coverage rule, and it has to apply here. So again, that's the risk that the employer takes by offering a health FSA.
Mm-hmm. All right. One more. Our FSA is calendar year. However, our open enrollment is fiscal year, so August 1st. If an employee is on a PPO plan with an FSA and elects to go over to our HSA plan in August, can they do so as long as they do not set up an HSA account for the rest of the calendar year?
Yeah, that's fine. I mean, but again, the employer can give the employee election to change their FSA coverage, because change in cost and coverage is not a reason to change your health FSA election.
Mm-hmm. Are you saying someone could use FSA money for COBRA premiums until the end of that plan year and then resume their own payments outside of the FSA's?
No, you can't. No, you can't use you can't use health FSA money for COBRA premiums. Now, the employer could change the premium conversion portion of the cafeteria plan. For example, if you're receiving severance, and take it out that way, but remember that health FSA money cannot be used for premiums.
Okay, that is all for right now.
Okay, so let's look at the interface between HRAs and FSAs. Under Code Section 105H6 defines a self-insured medical plan as a plan employer to reimburse employees for expenses of medical care for which reimbursement is not provided by any policy. And again, the payer of last resort principle still survives as practical matter when the employer also has an HRA unless the HRA requires health FSA to pay first. So what we're saying here is if neither plan mentions who pays first, the FSA first, but you can provide, no, I'm sorry. What I'm saying here, I got it reversed, excuse me. In that situation, the HRA, okay, under Code Section 105H6 defines a self-insured medical plan as a plan employed to reimburse expenses for medical care for which the reimbursement is not provided under any policy of accident or insurance. One exception, the payer of last resort principle still survives as a practical matter when the employer also has an HRA unless the HRA requires the health FSA to pay first. So in this situation, what that is saying is the HRA pays first unless the HRA says the health FSA pays first. So generally, if an employer participates both in the HRA and a health FSA offered by the employer and both plans cover the same expense, the employer must look at the HRA for reimbursement and second to the health FSA. However, an HRA plan sponsor may choose prior to the beginning of the health plan year to require the HRA document that the HRA will pay first. So the rule says if nothing's mentioned, the HRA will pay first. You have to change your documents to say no, the health FSA first. And the reason why that is true, whether you want to do that, because remember, if the HRA pays first, then the employee loses the money. So the HRA plan document must clearly specify that the HRA as the payer of last resort is available only after the expenses exceeds the dollar amount of the HRA. So you have to specify which one pays first. Let's look at the questions with HSAs. If a employee spouse participates under health FSA during the plan year and the spouse can be reimbursed for the employee's expenses, will the right to make the employee ineligible to participate under an HSA? Yes. Even if the employee never submits a claim for reimbursement, in that situation, if she could be reimbursed, then in that situation that makes that other individual, if they could be reimbursed, makes that individual ineligible for an HSA. So if an employer adopts a health high deductible plan during the year, may an employee elect to terminate participation under the health FSA. And again, as I indicated before, a change in cost and coverage is not a reason to change your election under the health FSA. Can an employee participate in either a health FSA or an HRA in the same month and still be eligible to make and receive a contribution? No. You can't be. The only way you can do that if you change your health FSA to a limited purpose FSA. A limited purpose is an FSA that only reimburses dental, vision, and preventive care. Secondly, you can have a health FSA that below the deductible for a high deductible plan, you reimburse dental, vision, and preventive, and above, it can reimburse anything. So you got to be real careful if you're going to put in either a health FSA or an HRA. In order to be eligible for an HSA, you have to be careful that there's no reimbursement of medical expenses below the deductible for a high deductible plan, which is $1,300 for single, $2,600 for family. Can an employer amend its general purpose FSA to a limited purpose during the year? Yes. Unofficial advice from the IRS, you can't give the employee an election, but you can amend your health FSA. Now, you could have some very angry employees that they're having surgery, they thought they could use the money, and before they could have the surgery, you change the plan. Not a good deal. Now, lastly, and I'm going to finish this up, then we can have questions. What happens if healthcare reform is repealed? Well, most of the proposals, for example, are limiting the $2,600 limit for health FSA. So before 2010, the health FSAs were unlimited. That will come back again. So again, make sure you understand that, and the proposal that just came out yesterday from the Republicans do repeal that. So again, the $2,600 limit will be repealed when this thing, and again, we don't know when it's going to be passed yet, so that's one of the proposals is going to be done. So this has been in effect since 2013. So secondly, restrictions on over-the-counter drugs and medicines, that will go away. So in the past, before 2011, you could be reimbursed for over-the-counter drugs in a health FSA. That restriction will go away once healthcare reform is repealed. All the proposals have that in there, so that's something that will happen. And again, this whole thing about exempted benefits is not going, again, with healthcare reform going away. And this was important because if a health FSA was an accepted benefit, then it would not be subject to healthcare reform. So again, if you put in an employer contribution to the plan, it could blow your exempted benefit status. It would make the plan subject to healthcare reform. With all the healthcare reform rules going away, that's no longer going to be concerned. Now lastly, how to deal with mistakes. Plan administrators should follow the debit card correction procedures and attempt to correct any errors seeking to repayment from a participant withholding the proper reimbursement from the participant's pay or offsetting the improper reimbursement. This happens all the time where the improper amounts are not taken out of the paycheck. The IRS guidance provides that the above correction steps are unsuccessful. You can't get the money back from the employee. That the improper payment should be treated as any other business indebtedness. In other words, it's included in the employee's income. When this step is applied, the employer must first request payment consistent with the collection procedures for all other business debts. If the payment is not recovered, then it should be treated as a forgiven debt and reported as wages on the Form W-2 for the year in which the indebtedness is forgiven. So again, this is something that's extremely important if there's an improper payment. IRS guidance indicates that under these circumstances, the mistaken payment should be treated as a business indebtedness, which, if forgiven, must be included in the employee's income and reported as wages in W-2. The employer can seek repayment of indebtedness from the participant on an after-tax basis through repayment by a check or after-tax payroll withholding in which the error, a year in which the error was discovered. If the denied debt is later determined to be eligible for reimbursement, the runoff period has not ended. The participant should be reimbursed for it up to the amount of the amount available on the participant's account. A denied FSA reimbursement should have been paid to a similar situation in which the employer withholds excess cafeteria salary reductions. But in both cases, an employer is contractually obligated to make the participant whole. So in this situation, if a denied claim should have been paid, in that situation, there should be reimbursement. In both cases, the employer contractually is obligated to make a participant whole. Upon discovering the error, the employer should reimburse the participant for a valid claim from his or her FSA account. The claim should be resubmitted if necessary for plan administration, properly paid according to the plan terms. The amount to be paid would be lesser than the full amount or the balance available in the account for paying the valid claim. So again, mistakes happen. One, if too little is taken out, or two, too much is taken out. Here, a denied claim has happened, so in that situation, the employer has to make it whole. Are there any questions?
Let me see. We have one. A change in cost of benefits is not a sufficient reason to allow a life event? Or is?
No. And again, the fine example, and the example comes up over and over again. You can change your election under the premium conversion portion of a cafeteria plan. You can change your coverage under a cafeteria plan. But if there's a change in cost and coverage, you can't change your election under a health FSA. That's the problem. That's what really upsets many employers and many employees. If they want to switch over to a high deductible plan and contribute to an HSA, there's no election that the employer can give to the employee. That's the problem.
If you ask for money due on an FSA claim and they don't pay it back, you would just include it as salary given on a W-2?
Correct. Correct. You are correct on that. It's a business indebtedness.
A substantial increase in out-of-pocket expenses is a reason to open in the FSA? I guess they're asking, would that be for a mid-year election change?
No, no. It has to be one of the 5 events. That's the problem.
All right. That's all we have for right now. And
well, thank you very much. And the next session is on compliance questions, right?
Yep, so we'll be covering some common compliance questions that Larry's been hearing from his clients, anything we've been hearing from ours, and that'll be on March 21st at 1 p.m.
So I have a series of questions that covers all areas, and what I'll be doing is I'll put the questions up and I'll give you the answers to all the questions, but these are questions I've been getting from my clients over the years, and they're very, and this is, you may, again, and what you may want to do during the presentation, this is a good time to collect all the questions you've been asked for a while and throw them out there. So we're going to have a discussion of exactly what's the right answer with some of these questions. So we'll be covering COBRA, we'll be covering ERISA, we'll be covering all kinds of areas of the law that I've been getting questions on, and I'll be giving answers on exactly how to address those issues. Okay?
All right. Thank you so much, Larry. And thank you all for coming.
Bye-bye.
Bye.